Hello friends, very warm welcome to my business laws channel. Today friends, I'm going to take up case studies based questions and how to answer them. You know friends, whether it is BCom Honors Semester 1, BCom Semester 2, CA, CS, LLB, BA, LLB, in all these examinations, application based questions are asked or case study based questions are asked. Now, sometimes you know what happens, students get panic. Looking at the size of the problem, they find it very difficult to answer. Okay, so I'm giving you tips in this video how to solve this case studies based questions, how to answer them. Process of solving case studies. So this process I'm going to discuss in my today's video. There are four parts. Identify the case study, provisions of law, analysis of the case, and the last is conclusion. So friends, in BCom Honors or BCom Semester 2nd, BCom Honors first semester and BCom second semester, there is business laws paper. Another professional examination also, case studies are asked in the examination. So these four steps you have to follow, four parts, you have to answer the case studies when they are given to you in the examination. So in BCom Honors Semester 1 and BCom Semester 2, first two questions are from ICA. And third question is from special contracts, fourth question is from Sale of Goods Act. Till fourth question, in every question almost there is case study problem which you have to write. So question has got theory question as well as the case study is given to you. So case studies are asked in BCom Honors as well as BCom from the Indian Contract Act, from special contracts, or from the Sale of Goods Act. Remember, no case studies asked from LLP Act or IT Act 2000. These are the three acts: ICA, special contracts, and then Sale of Goods Act. From these acts, case studies based questions have been asked in the previous examinations of DU. So friends, I have told you four parts. You have to answer such questions in four parts. The very first is identify the case study. Second is provision of law. Third is analysis of the case or relevant case law. If you remember, you have to write. And then conclusion. You have to conclude what has been asked in the question. Okay, so you have to give your answer. 5 problems along with their solutions I will take up, which will clarify you, which will give you more clarification. So the first problem is A sells his grocery business, including goodwill, to B for a sum of rupees 5 lakh. It is agreed that A is not to open another grocery store in the whole of India for the next 10 years. A opens another store in the same city 2 years later. What are the rights of A? Now friends, A has sold his grocery business including goodwill to B. A is the seller of the business and B is a buyer of the business. Section 27 provides, friends, any agreement which is made in the state of trade is void. But this rule is not applicable in certain exceptional cases. So friends, read the problem very carefully. First of all, identify from which chapter, from which act, and which chapter, which heading this problem relates or belongs. And then, what are the provisions regarding that. Then apply the provision in the given problem and then give the conclusion. So I've told you friends, this particular given problem is from the heading agreements which are made in the state of trade are void. But there are 2 exceptional cases where this rule is not applicable. One is statutory exceptions, sale of goodwill, and restrictions under the Partnership Act 1932. And second is judicial interpretations or judicial exceptions. So here seller is A and seller of the business is A and buyer of the business is B, and the consideration is 5 lakh rupees. The agreement has taken place. A is not to open another grocery store in whole of India. Friends, remember, restrictions are there sometimes, but these restrictions are not void, they are valid. But remember, when we talk about the restrictions should always be reasonable. Then only they are valid. Now, restrictions reasonable are when A is not to open another grocery store in the same locality for a period of 2 years or say 10 years or 5 years. This restriction seems to be reasonable. This restriction which is given to us in the problem in the whole of India for the next 10 years, whole of India for the next 10 years, this seems to be unreasonable. A opens another store in the same city 2 years later. Okay, so friends, here now this restriction is unreasonable, whole of India. Okay, so friends, here as the restraint is unreasonable, so this restraint is not valid, it is void. Okay, so he opens another store in the same city 2 years later. Same city he cannot open. Okay, so friends, here the buyer of the business will have the right to take action against the seller. But agreement term is, he's not going to open another grocery store in the whole of India for the next 10 years. Whole of India. But if it is like this, that in the same locality also, he cannot open the store because then he will be taking away all the customers of his previous business. So here, we will have the right to take action against a person. Okay, so you should be very careful regarding this, whether the restraints are reasonable or they are unreasonable. So friends, first of all, in this problem, we have identified the problem, to which heading, which act it belongs, what are the provisions regarding that, and then we have applied the provisions in the given problem, and after that we have concluded. Now coming to the next problem, which is problem number 2. A promised to pay to his wife B a fixed sum of money every month for her separate residence and maintenance. This agreement was written and registered one. In this agreement, certain quarrels and disagreements were also mentioned between A and his wife. Discuss citing case law if the agreement was enforceable. Friends, this given problem relates to the heading consideration, no contract. Exceptions to the rule, no consideration, no contract. The very first exception is agreements made on account of natural love and affection. Section is 25, subsection is 1. Okay, any agreement which is made in the absence of consideration, but it is made on account of natural love and affection. 4 conditions are there. Promise must be made in writing. It must be given in writing. It must be registered, and it should be made on account of natural love and affection. And parties must stand in near relation to each other. So parties are standing in near relation to each other because parties must be related by blood or they should be related by marriage. And their husband and wife, they are related by marriage. All conditions are there, but one condition is given here. In the agreement is written, certain clauses and agreements were also mentioned between husband and wife. Friends, the fact of this case are similar to the case law, which is Rajlakhi Dabi, Bhutnath Mukherjee. Okay, so in this case, friends, 4 conditions I have already mentioned. Okay, so 4 conditions are not going to be satisfied. Agreement has not made on account of natural love and affection, which is one of the requirements. So this agreement will not be enforceable. This is the conclusion. Why it will not be enforceable? Because one of the requirements or conditions has not been satisfied. So the given problem, I have already told you in the very beginning, it relates to the heading, exceptions to the rule, no consideration, no contract. Moving ahead, the third problem is A, who is trying to sell an unsound horse, forges a veterinary surgeon's certificate stating that the horse is sound and pins it on the stable door. B comes to examine the horse, but the certificate goes unnoticed by him. He buys the horse and finds later on the horse to be unsound. He wants to avoid the agreement under the plea that he has been defrauded. Will he succeed? Friends, this given problem relates to the heading fraud. You know, fraud has been defined under section 17. And one of the elements of fraud is a deceit which does not deceive is no fraud. That is, friends, the other party must be cheated. The seller has tried to defraud the buyer, but buyer was not cheated. It is given to us. Certificate was displayed by him on the stable door by the seller, but buyer has not examined it. Buyer did not examine the horse, but the certificate, he did not see the certificate. So it means the buyer has not performed his duty. He buys the horse and finds later on the horse to be unsound. Let the buyer beware. Buyer must be very careful while buying the items. If he is not, he cannot subsequently hold the seller responsible for the loss. So Horsfall versus Thomas is a very important case law regarding this, where fraud was played by the seller, but buyer was not cheated. A deceit which does not deceive is no fraud. And now when in the given problem, the buyer wants to avoid the agreement under the plea that he has been defrauded, he has not been defrauded. He will not succeed. Okay, now the next problem is problem number 4. A gives some cloth to a tailor for making a suit of it. The tailor's charges are settled at rupees 500. After the suit is ready, A tenders rupees 500 for the charges, but the tailor refuses to deliver the suit till A pays an old debt of 200 rupees. Is the tailor entitled to do so? Friends, this problem pertains to the chapter bailment. Okay, lien is the right to retain the property till the dues are paid. Lien can be of two types. One is the general lien, second is the particular lien. And this given problem pertains to the heading particular lien or special lien or specific lien. Now, A has given the cloth, A is a bailer and tailor is the bailee. So the main purpose of bailment is conversion of cloth into the suit. And charges are settled 500 rupees. After the suit is ready, A tenders 500 rupees for the charges, but tailor refuses to deliver the suit till A pays an old debt of 200 rupees. Friends, this specific lien can be exercised by the bailee till his charges are paid. Once his charges have been paid, then the bailee has no right to retain those special property or goods in respect of which certain labor has been expended. So he has done his job. He has expended the labor. Charges are 500 rupees, but that charges have been paid. And now tailor has no right to retain till the old debt of rupees 200 is paid. For that, he can take action against him, but he has no right to exercise this particular lien. And one of the features of particular lien is particular lien can be exercised only, by the bailee till the charges are paid. But charges have been paid. Tailor will have to deliver this suit to the owner, a person. I hope, friends, you must be clear. And if you still have any doubt regarding any of the problems, you can always write in the comment section. I will always clarify. Now, coming to the last problem, which is X of Delhi sold certain goods to Y of Kolkata, and these goods were to be sent by railway. When the goods were in possession of railway authorities, seller received the message that the buyer has become insolvent. Which right can be exercised by the seller and how? When is this right lost? So friends, this given problem pertains to the chapter Unpaid Seller and his rights. You know, unpaid seller has rights against the goods. 3 rights: right of lien, right of stoppage of goods in transit, and right of resale when the ownership has passed. When the property and goods has passed, 3 rights are available to the unpaid seller against the goods: right of lien, right of stoppage of goods in transit, and right of resale. So friends, right of lien can be exercised by the unpaid seller when the goods are in the possession of unpaid seller. But in the given problem, we are given that the goods were to be sent by the railway. Now, when the goods were in the possession of railway, it means the possession of the goods has been given by X, to railway. Now, it is a duty of the railway authorities to make available the goods to Y of Kolkata. It means the goods are in transit. The goods are with the railway authorities. And now the seller has come to know, X has come to know that the buyer has become insolvent. So friends, he cannot exercise the right of lien because the goods are not in his possession. He can exercise the right of lien only when the goods are in the possession of unpaid seller. So he has lost the possession, so it means he has lost the right of lien also. And now the goods are in the possession of railway authorities. If he is not having the right of lien, there comes a second right, which is known as right of stoppage of goods in transit. So second right of stoppage of goods in transit can be exercised by the unpaid seller through the railway authorities. How can he exercise? He can inform the railway authorities that buyer has become insolvent. You should not deliver the goods to the buyer, at the point of destination. And then it becomes the duty of the railway authorities. They must follow the instructions given by the unpaid seller. And second is, he can regain the possession of goods. He has lost the possession of goods. He can take back the possession of goods from the railway authorities. In both the cases, railway authorities should not deliver the goods to the buyer at the point of destination, and they should always follow the instructions given to them by the unpaid seller, X in the given problem. Now the last part of the question is, when is this right lost? So all provisions pertaining to right of stoppage of goods in transit, they have been provided under sections 50 to 52 of the Sale of Goods Act 1930. When is this right lost? There are a number of cases when the transit comes to an end. When the transit comes to an end, then the right is also lost. Transit will come to an end when the railway authorities part with the possession of goods, or when the buyer makes a payment. Okay, or when the buyer has forcibly taken the possession of goods, when the goods are still in transit. Goods are in the possession of railway authorities, but buyer has forcibly taken the possession of goods from the railway authorities. Now it means the railway authorities have lost the possession of goods. So then the right will come to an end. So the moment the railway authorities, they lose the possession of goods, then the unpaid sellers, this right of stoppage of goods in transit, will also come to an end. So friends, all the 5 case studies I have explained in my today's video. And if you have still any doubt, you can always write in the comment section and I will definitely answer. So friends, it is all from my side. I hope this explanation today must have given you the clarity that how to answer case studies if they are asked in the examination. I hope you must have understood this content, or you will understand whenever you will watch this video. Do press on the bell icon so that you can get notifications of my future videos. Do subscribe to my channel if you have not subscribed yet. Okay friends, keep smiling and stay blessed always. We will meet soon. Okay, bye-bye.